All right, we're going to go ahead and call the Senate Committee on Revenue and Economic Development to order. Madam Secretary, please call the roll.
Senator Buck, Senator Dunyate, Senator Severs-Ganser, Senator Spearman, Chair Neal.
Here. All right, so just some few housekeeping items. Make sure you silence your devices. We're going to have two bills that will be heard today. When you come and testify, can you please spell your name if it is a very hard name to decipher? And we will open up for AB 53, which is on penalizing tobacco sales.
Good afternoon, Chairwoman Neal, Vice Chair Jonate, and members of the Senate Committee on Revenue and Economic Development. For the record, I am Mike Morton, Special Assistant Attorney General to Attorney General Aaron Ford. With me here today is Stacey Williams, Senior Deputy Attorney General, and David Pope, Chief Deputy Attorney General, who is joining us in Las Vegas. Chief Dag Pope and Senior Dag Williams lead the Tobacco Enforcement Unit in the Office of the Attorney General. The Office of the Attorney General consists of nearly 350 dedicated, hardworking individuals committed to enforcing Nevada law and upholding justice for the protection and benefit of the residents of this state. As the state's chief law enforcement officer, the Attorney General represents the people of Nevada. In doing that, the office has aggressively defended tort claims, saving the state more than $1.3 billion in taxpayer dollars, processed over 18,000 constituent complaints and over 39,000 constituent inquiries for information and services, prosecuted elder abuse, and provided support for law enforcement agencies across the state to do the same, while also attending nearly 500 guardianship hearings for elder and vulnerable Nevadans, and obtained $330 million in funding to combat the opioid epidemic. Another large part of ensuring justice for Nevadans is this office's role in consumer protection, which is why we have brought Assembly Bill 53 before you today. Assembly Bill 53 seeks to protect Nevada's youth while ensuring that the state's laws related to tobacco sales are strictly enforced. With that, Ms. Williams will take the committee through the proposed changes in AB 53.
Thank you, Chairwoman Neal, Vice Chair Dunyate, and committee members. Good afternoon, and thank you for your time. I am Senior Deputy Attorney General Stacey Williams. Stacey is Stacey, Williams, Williams, and I am here to present for your consideration Assembly Bill number 53, which proposes changes to NRS 370.521 with respect to the prohibited sale and distribution of tobacco products to persons under 21 years of age. It is NRS 370.530 that vests the Attorney General with the authority to investigate and prosecute any civil or criminal violation of Chapter 370, and the Tobacco Enforcement Unit within the Taxation Department of the Nevada Attorney General's Office enforces Nevada's law, NRS 370.521. 1, prohibiting the sale of tobacco and vapor products to anyone under the age of 21. Our office has 2 law enforcement officers and 6 underage inspectors who are responsible for conducting youth compliance inspections across our state, and there are over 3,200 licensed tobacco retailers throughout our state. Our officers and inspectors are responsible for inspecting every tobacco retailer at least once every 36 months. As it exists now, NRS 370.521 only imposes civil penalties for first-time violations on the persons who actually make the tobacco product sale, which in essence would be the sales clerks, with increasing penalties for every subsequent sale within a 24-month period. Section 7 only issues warnings to licensees for the first and second violations. Civil penalties are not imposed until the third violation within a 24-month period. So included with the inspections that our investigators do, there's an obligation to conduct SINAR inspections. Our team averages about 100 completed inspections each month, with a focus on SINAR inspections from October until about June of each year. Each state must maintain a SINAR inspection retail violation rate of 20% or less, and if the SINAR retailer violation rate exceeds 20%, Nevada could face a penalty of 10 to 40% of our block grant, and so that's dollars lost to Nevada. So in talking about Assembly Bill 53, it has three main areas of focus. The paramount focus is to keep tobacco and tobacco-related products from being sold to youths and persons under the age of 21. The second area of focus is to strengthen the accountability of licensees and to encourage them to take stronger measures to ensure the cessation of sale of tobacco or tobacco-related products to youth. And the third area of focus is to lower the youth sales violation rate, in particular our SINAR violation rate to below 20%. So AB 53 seeks to modify portions, to modify portions of sections 7A through, there we go, 7A through D to add civil penalties for licensees who violate the section. AB 53 proposes to edit section 7A to impose a civil penalty on the licensee of $2,500 for the first violation of subsection 1 of NRS 370.521 within a 24-month period at the same premises. Section 7B would be modified to impose a civil penalty of $5,000 for a second violation within a 24-month period at the same premises. Section 7C would be modified to impose a civil penalty of $5,000 for the third violation within a 24-month period at the same premises. And Section 7D would be modified to impose a civil penalty of $10,000 for a fourth and any subsequent violation within a 24-month period at the same premises. The proposed effective date for the new law would be slated for January 1st of 2024. So these proposed changes are particularly important because the overall health of Nevada's youth and Nevadans in general is at stake. Tobacco is a product that kills you when used exactly as directed, and youth vaping has become a nationwide epidemic. The impact on tobacco-related disease and deaths is an ever-increasing financial burden on our country as well as our state. And statistics show that the instance of high school students in Nevada who report that they smoke or use e-cigarettes is much higher than the national average of all high school students, despite the fact that we have strict laws already in place in Nevada to prohibit the sale of tobacco and tobacco-related products to persons under the age of 21. Despite the passing of Nevada's Tobacco 21 law, Nevada's youth tobacco sales violation rate is consistently high, which puts the health of our youth in jeopardy. So I mentioned three important areas of focus. That third important area of focus that I mentioned was Nevada's need to lower our youth sales violation rate, in particular our SINAR violation rate, to well below the 20% threshold. So just to give you some background, what is SINAR and why is it important? In July of 1992, Congress enacted the Alcohol, Drug Abuse, and Mental Health Administration Reorganization Act, which included the SINAR Amendment, and that's named after its sponsor, Congressman Mike SINAR of Oklahoma. And it was specifically aimed at decreasing youth access to tobacco. The SINAR Amendment requires every state to enact and enforce laws prohibiting the sale of distribution of tobacco products to youth, and they tied that the enforcement to the Tobacco Regulation for Substance Abuse Prevention and Treatment Block Grant. Nevada receives over $18.5 million in funding from that block grant each year. But in order to receive the full award, Nevada must comply with the SINAR Amendment and show a retail violation rate of under 20%. Failure to maintain that retail violation rate of below 20% can result in our state being penalized between 10% to 40% of that block grant funding. And so what that means for us in loss of dollars is $1.8 million to $7.4 million in federal funding to our state. As of the 2020 SINAR reporting period, Nevada's violation rate was above 25%. The 2022 SINAR reporting showed Nevada at a violation rate that remained above 25%. To make matters worse, Nevada was the only state above the 20% threshold for 2020, for the 2020 annual SINAR reporting period. And so that put our state on a national platform for noncompliance. In considering the proposed modifications outlined in Assembly Bill 53, we reviewed tobacco-related statutes in several other states with consistently lower SINAR retail violation rates than ours. And our research revealed similar and in some cases more stringent practices than those that we've proposed with respect to penalties issued to retailers for violation of statutes prohibiting the sale of tobacco products to minors. And so just to give you some examples, in Washington State, Washington issues escalating civil penalties to the licensee on the first and second violations, as well as escalating tobacco license suspensions for the third and fourth violations within a 36-month period. For a fifth violation, the licensee's tobacco license is revoked with no possibility of reinstatement in 5 years. In Wyoming, escalating civil penalties are imposed on both the clerk and the retailer for the first and second violations. And for the third and subsequent violations within a 24-month period, the retailer is issued a civil penalty of $750 and up to a 180-day injunction prohibiting the sale of nicotine products. Wyoming does, however, allow waiver of the retailer's fine, but for the first offense only, and only if that retailer can show that it has an established training program for its employees and established disciplinary sanctions for those employees. We also looked at Arkansas. In Arkansas, the clerks and owners can receive fines of up to $100 per violation. In addition to that, the state created the Arkansas Tobacco Control Board in July of 2019, and that board can directly assess penalties for those violations of up to $250 for the first violation. For licensees who are subsequently found in violation within 48 months of the first violation, the fines escalate, and you see upwards to $2,000 on a fourth violation. We looked also at Delaware. They assess a penalty against the licensee for the first violation and shorten the window for subsequent violations to within 12 months of the first violation for escalating fines. And then they add the component of license suspension on the second violation, and it is for up to 6 months. And then we looked at New Mexico as well, trying to compare comparable states and comparable geographies if we can. And they are consistently below 11%, but as that state's numbers started to trend upwards, they passed stricter laws with respect to their retail violations. As of January 1 of 2021, New Mexico not only assesses penalties against the licensees for violations at a higher threshold than any of the previous states mentioned, they introduce license suspension on the first violation. And so they have stricter fining structure as well. You notice it goes upwards and escalates beyond $10,000 and ultimate permanent revocation of a license. And then finally, we looked at Utah. And Utah also assesses penalties for the first violation with stricter penalties in place if the actual violator is a store owner. They have a graduated scale for subsequent offenses, and if the retail employer sells a tobacco product to a minor, the retailer is subject to escalating fines for the first and second offenses within a 1-year period. For a third offense within 2 years of the first, the retailer is subject to a fine of $2,000 or a 30-day permit suspension. A fourth violation within 2 years of the first carries that $2,000 fine and permit revocation. And Utah also makes a special distinction. It distinguishes its penalty structure so that if it is the actual store owner who sells to the minor, there is a $2,000 fine assessed to the retailer for the first offense. If the store owner is found in violation a second time within 1 year of that first violation, the retailer is subject to a $5,000 fine and permit revocation. Utah also has a tobacco specialty business distinction for retailers where tobacco products constitute 35% of the business's gross receipts, or if tobacco-related products take up 20% of the retail floor space, or if that business engages in the sale of any flavored e-cigarettes. And that special distinction carries additional escalating fines that are larger. And so for those types of businesses, the first violation has a $5,000 fine and a 30-day license suspension. And if there's a second violation within 2 years of that first one, for a tobacco specialty business distinction, that fine is $10,000 and the licensee's permit is revoked. And so we just wanted to show you some other states that have stricter measures in place, and they are trending below the 10% rate when it comes to their retail violation rate as compared to our 25% rate. The commonality among the highlighted states is that the issuance of penalties against the retailer for first offenses and sign-our violation rates that are consistently below 20%. So first offense, low sign-our rates. As you all are considering the Assembly Bill 53, you may be wondering how our new tobacco age verification law that went into effect on January 1st of this year is impacting our state sign-our rate, and if that alone lessens the necessity to make the statutory modifications that we're proposing in AB 53. Just to give you a bit of historical reference, on December 20th, 2019, the President signed into law legislation raising the federal minimum age for the sale of tobacco products from 18 to 21. At that time, our state sign-our rate was above 22%. But as a result of the heightened sensitivity to the new federal law, we experienced a significant decrease in our sign-our violation rate. However, within 1 month of that drastic decline, our violation rate began to trend upwards. Within 2 months, our sign-our violation rate was again approaching 18%. So looking at our violation rate for the latter months of 2021, Nevada sign-our RVR, our sign-our rate remained consistently above 20%, reaching thresholds as high as 32%. And that brings us to our current rate. Prior to the new age verification law, our sign-our violation rate was over 22%. So if we're looking at the end of last year, we were above that 20% threshold, which puts us in jeopardy of losing our block grant. When the new law went into effect on January 1st, our January sign-our rate plunged to 7%, which is awesome. However, just as we feared and as we expected, our inspection rates have slowly started to tick up. Very slightly in the month of February, and we've been consistently rising ever since. Our retail violation rate in February was 8.9%, our March rate was 10.6%, and our April rate was 15.7%. So even this quickly, so we've had this law that went into effect in January, this quickly 4 months later, we're seeing ourselves tick upwards to that 20%. If history repeats itself, as focus on the new age verification law wanes, our violation rate will continue to trend upwards. And as such, Nevada can't wait beyond this legislative session to take measures to ensure that our retailers hold themselves accountable and that their employees and they hold themselves and their employees responsible for preventing tobacco sales to our youths. Nevada has to act now. So, in an effort to lower Nevada's instances of youth tobacco sales, to decrease our sign-our violation rate, and to hold retailers accountable in those efforts, we propose that NRS 370.51 be modified to reflect the issuance of civil penalties against the retailers, beginning with the first and escalating through the fourth and subsequent violations at the same premises within 24 months. Thank you.
Thank you for that. Members, any questions? Senator Dunyate, and then it's Senator Ganser, are you going to have? Okay.
Thank you so much, Chair Neal, and good afternoon. Thank you so much for your presentation. I do have a few questions as to the legislation itself. So I think this is a good conversation to have where we're facing the public health challenge of youth vaping and the consequences of what we're seeing in our schools. I think when I was in high school, vapes had started to come out, and now since then we've had flavored vaping, et cetera, to what we have now, which is 21 and over. And so the question that I had was, in the presentation you showcased where there are some states that have the fines and penalties, and then they have the corrective actions where there's a suspension or a revocation of the permitting process. And I was looking at the amendment that was of how this bill was initially introduced on the assembly side. So can you walk us through what was changed in the assembly side and what the concerns were with the revocation and why that was taken out?
Okay. So Stacy Williams for the record, and through Chairwoman Neal, and to you, Senator Doñate. To answer your question, the first iteration of this particular bill instituted a lower fining structure and then had revocation periods, but the revocation periods were at 30 days and 180 days were the initial pieces of the puzzle there. And so as we talked to both the industry side and the health side, it became apparent that we needed something that would be a larger impact. And so if you listen to the hearing structure from the assembly side, one of the things that the retailers talked about is the impact fiscally for them when it comes to not being able to, when it comes to paying a fine for tobacco versus when it comes to being suspended, and then thinking about the length of time that it would take for the suspension period to actually go into effect. We are talking 6 months to potentially 8 months or a year later because of the hearing structure. So something that would be of impact faster and something that would really make an impact with the retailers themselves. And so that's where the escalated fining structure came from.
Thank you so much. And if Chair, if I can follow up, I appreciated your response because I think it's important for us to understand the context. Just from my personal viewpoint, I think that if there is a retailer that has been caught 4 times, right, as part of the structure within the 24-month period, that's an egregious case of violating law that can jeopardize the public health of, if we're considering who's buying this, right, it is feeding to the problem that we have with youth vaping. And so I think that is a conversation, and I would like to see the revocation at least towards if it gets to that point with either the third or the fourth occurrence. Just random questions since I haven't had the chance to see this. So if you can touch one request. Do we do annual inspections, or are they segmented every other year? What's the case for that? And then also, if you can touch point on online sales. I know that, I actually, during this hearing, I was trying to check what the process was even to buy a vape, and it just said, are you 21 and over? Yes, and then there we go. I was already looking it up. So if you can touch point on both the online retailers and the perspective of the inspections, I think would be helpful.
Okay. Stacy Williams to Senator Doñate. To answer your first question with respect to the third and the fourth, so the way that the structure goes in terms of the inspections, we have an obligation to inspect every retailer once every 3 years. And so there are 3,200 plus retailers that sell tobacco in this state. The likelihood of getting to a third or a fourth touch point for an individual retailer is probably close to less than 10% because of the obligation to see each one. And if you're thinking they're doing 100 inspections on average in a month's time, to get through over 3,000 takes about 3 years. So that third or fourth opportunity for the retailer to be in violation is slim to none. So that's to answer that first question. That being said, that's why the escalated fines are on the front end. So for that very first violation, I think what was happening before in the law is that the retailer did not have anything other than a warning on number 1 violation, number 2 violation, and it wasn't until the third violation where the retailer was ever brought into the loop. So by bringing the retailers into the loop on the very first violation, it has an instant, immediate impact on them as well. Not just the clerk, because it was the clerk, that was receiving a fine, and this is a person, that is coming to work and typically a minimum wage worker, and that fine definitely impacted them. but didn't necessarily impact the retailer. So we wanted to impact the retailer right away. When it comes to online sales, you have to have, in order to sell tobacco in the state of Nevada, you're supposed to have a retailer license and have a presence, not online sales, in our state.
Senator Ganser.
Thank you, Madam Chair. So I'm looking at the penalties, and if you're someone who sells to someone, the penalties are not that substantial. You've got tiers in Section 1, subsection 6. A person who violates subsection 1 is liable for civil penalties. It's 100, it's 250, it's 500. But then you have, if you're an employee or an agent, so you're not the owner, you're an employee or an agent, you go to 2,500, 5,000, 10,000. When you gave some of those examples, it seemed like if you were the owner operator of a business, it was higher. So in this case, you may be employing someone who breaks the law, but then, I mean, it's, so, and I was one of the individuals who supported the taxation of vaping products because I wanted to make sure it didn't get to the youth. But I also know that employers, small businesses will hire people, or those people may incur an infraction, and it seems like these penalties are lopsided. So if you can explain a little bit why, if it's any person, it's certain levels, but if you're an employee or an agent, it's 5 times as much or so.
Okay. So Stacey Williams to you, Senator Severs-Gansert. So the structure as it exists right now only impacts the seller, and that might be an employee who is a clerk, but it also could be the owner. That's the structure that starts at the $100 fining structure. So if you are the actual person who sells the tobacco product to a person under the age of 21, then you are subject to civil penalties beginning at $100 for the first violation, $250 for the second violation. The fines that have the higher escalation are for the licensee. It is the person that actually has the license for that business as where that fine structure increases.
Thank you. But when you hire employees, sometimes probably minimum wage employees, you can't control them all the time while they should be very cautious. So I understand sort of the intent, but I'm concerned about the small business owner who hired, someone who's 23 years old for minimum wage, who had a couple of friends come in and they sold it, underage and got caught. So they're just very severe penalties when the owner is not the actor. And so I guess it doesn't make sense to me because we want to make sure that there are substantial penalties, but we also don't want to put people out of business. So I'm concerned about the level for those, especially relative to sort of your basic fines that you have.
Stacey Williams to you, Senator Severs-Gansert. Absolutely, we understand that we don't want to put businesses out of business as a result of the acts of their employees, but we also have that subset of business owners who are telling their employees that they need to make the sale, whoever's coming in, and that are encouraging their employees to not follow what the law is. And so we have that side of it. We also have we want to make sure that the retailers are educating their employees, that the retailers are having the proper measures in place. Now, here's the thing, coupled with 370.521.3, where it is mandatory that every business has scanners or that they have automated technology in order to be able to age verify. That automated technology and those scanners should not allow an employee to make a sale and should, very much show them that this person is not of age to be able to be sold to. And so if they're blatantly doing that, then there needs to be stronger measures in place, and ultimately, in this instance, it's the employer that is responsible.
Thank you, if I can follow up. So you talked about the electronic verification. Well, they have that now, and we're still over 25%. So
Go ahead.
Is that correct?
Well, it's not quite correct because they're supposed to have it now. There's so many retailers that do not yet have it. And so the law went into effect on January 1st. And so the expectation is that the employers have had over a year's time to be able to put those measures in place, but you would be surprised at how many of the inspections that we've done that they've not yet secured that scanning technology or that automated technology. So as they are coming on board with getting that technology and they are following the law in that respect, I think the two laws coupled together will help us keep our rates low.
Thank you. That's all the questions I have for now, but I do think that's an issue. If retailers maybe can't afford to get the electronic software, the product, and then we have these high penalties, I think we just need to be thoughtful about this. Thank you.
And can I speak to that, Senator Severs Cancer, with respect to how much it cost? Because the law is designed for the retailers to either have scanners or to have automated technology. There are free technologies that the retailers are able to use that still allow them to be in compliance with the law and have those inspections. The FDA provides it, as well as some other automated functions that can be used simply on your cell phone. That are applications that can be used free of charge to those retailers that do not want to get scanners, which is why the law says scanning technology or automated technology.
Thank you for that information. Maybe we can talk about it further, like, at a different time. Thanks.
Senator Spearman.
Thank you, Madam Chair. So I just had a question that maybe it's rhetorical. In 2019, the President signed the legislation raising the federal age from 18 to 21. And I've always had these discussions, what about service members? And I know that the law should be the same, either on base or off base. But what the military has done in terms of smoking cessation, I'm sure that's helpful. But there's always the question, if someone is old enough to go to war, why wouldn't they be able to? And this is not advocating either or. I'm just trying to get clarification on that.
Okay. Stacey Williams to you, Senator Spearman. So the law is 21, and the states have elected on their own on how they're going to implement that law. There are still a few states that do not have the 21 law yet, but choose to acknowledge the federal law. It used to be that it was 21 for anyone that was not service-related, and for the military that the law was 18. Across the board now, the law is 21, and that's the law in our state.
Senator Buck.
Thank you, Chair Neal. Is there a whistleblower platform for those who are encouraging their employees to sell to minors?
Stacey Williams to you, Senator Buck. There's not a formalized whistleblower platform, but we do have a tobacco enforcement email that we receive messages from those that are in the public that have experienced either maybe vaping products being sold to their use, and they actually will contact us, and we have our investigation team go out and inspect those specific retailers that have violated in that way, or at least have had an allegation of having violated in that way. We also have sometimes employees that will say that this is what they were told to do, and they will anonymously submit to that line as well.
Okay, you're good? All right. I have a series of questions. So I want to go back to the data, the block charts. So it was interesting to me where you see like an 8, 2021, 7, 2021, 11, 2022, 12. I'll just stick with those, and then I'll go to the 12, 2022 ones. So you have a lower number of inspections, so the percentage is higher, right? So how did we, I guess, aggregate this information? Because you have clear months where clearly the percentage is going to be well above because you didn't go and inspect. And then when you get to 12, 2022, where you have a total inspections of 126, you have then the 22.8%. So can you just talk to me about how you average this data?
Yes, so Chair, Stacy Williams to Chairwoman Neal. So when we're looking at our sign-our rates for 2021 and 2022, we're consistently above 20%, whether we have the lower threshold of inspections done or the higher threshold of inspections done. There are months that we have lower inspections. We have 2 investigators, and they have to go out 2 by 2. We lost an investigator in one of those years, and so you'll see the numbers drop lower. We also have the sign-our timeframe, and so when you're talking about sign-our, we have 800 random selected locations that must be visited in the sign-our period. So you'll see an extreme focus between the months of October and the months of June in order to get those sign-our inspections done. You'll see a larger threshold of inspections being done when our investigators can be in the South, because in the South, there's going to be a lot more retailers and the geography is more concentrated. When they travel to the North, they usually will concentrate on the North for 2 weeks to a month's time. And so if they're in the North in a more dense, in an area that's not as populated, you'll see the numbers will go down. In terms of the number of inspections done. So like you saw this month in April, the inspections, there were 70 inspections that were done as compared to in January, there were 120 plus done. They were in January and February in the South. In April, they were in the North.
Thank you for that. So, and then my second follow-up on the data is, I was looking at, 2021, part of 22, we were still heavily in COVID, right? So was anything revised at the congressional level that dealt with the inspections to at least try to figure out how you should further examine this data in absence of people moving around and physically going places?
Yes. Stacy Williams to Chairwoman Neal. So because of the pandemic, there actually was a hiatus for 3 years when it came to penalty structure. So none of the states were subject to a penalty for a 3-year period. Because of that, because in many instances, states were not conducting any inspections at all during the 2020 year, because everything shut down. And then they're ramping back up in 2021. And so for the year 2020, for the year 2021, and for the year 2022, we were in that hiatus period. And so although we were above 20%, we were not subject to the penalty structure. However, 2023, that ended. And so it's imperative that this year we make sure that we are below that 20% threshold so that we're not impacted to the tune of $1.8 million.
Okay, thank you for that, because that's what I was trying to figure out, because I was looking at all of the data blocks as a representation of how this problem is growing and how this problem is, you're substantiating the problem, but that's why I wanted to understand about what the feds had to say around COVID. So now I have a different question, though, that's actually related to the bill. So in section 1, and I know that's something that we're probably just glossing over because we're jumping right to the fines, but in section 1, although existing law, it matters because now of the heightened fines, right? So in section 1, you have, it includes vape and then alternate nic products that are made or derived from nicotine. So then I guess it is still section 1. Well, section 1 sub 7, it's like a really, really long section 1. So in section 1, section 1, and then when you go and look at section 1 sub 7, then you have your licensee change where it's an employee or an agent. And so my question there was, now we have heightened fine, it's derivatives. Who is classified as an actual agent of the licensee?
So
line 3 on page 2. this is where you have an employee or agent of a licensee has violated subsection 1, which is in sub 1, section 1, sub 1. And so I am drawing these two together because I'm trying to figure out who then is an agent of the licensee, right? Because now with this first, any derivative of the product, 2, now an agent of, who may not be in constant control or even direct control or indirect control. Now we're applying increased penalties to them upon a series of violations. So I was really trying to understand, who is this agent that is now going to be on the hook for a derivative of nicotine or a derivative of vape? Because it says, you know, in section sub 1, we have any all the way through, right? So that's any product. So can you help me understand that part?
Yes, okay. Stacy Williams to Chairwoman Neal. So in section 7, where it says if an employee or agent of the licensee has violated subsection 1, they mean the actual person that has made the tobacco-related sale. Sometimes in retailers, it will be the clerks that are the employees, but sometimes someone will have a friend come in and be their clerk for the day. And so that's who we're talking about with respect to the agent, is whoever the licensee has vested with the responsibility of selling tobacco in their establishment, they're responsible for.
Thank you for that. So, but the agent, though, I'm sorry.
What?
Okay. So in my world, an agent doesn't always have certain legal responsibilities, as they're not the same. They could be different depending on your role, right? If you're an agent of a licensee, to me, there's a very different legal definition of an agent. So I want to know, what are the characteristics of the agent in NRS for this particular section?
Chairwoman Neal, it is an individual who has, in the licensee's establishment, made a sale that is a non-employee.
So they are now vicariously liable, jointly liable, or it's just the individual, not the licensee and the agent?
No, so this is the one that made the violation.
Okay.
The person that is receiving the fine is the licensee. So what it is saying is, if licensee, someone that you have employed or someone that you have vested with the responsibility of selling tobacco to someone in your establishment who is a non-employee of yours, if they violate section 1, then you, the licensee, are subject to the penalty. So the penalty only goes to the licensee.
Okay. I don't read it that way, but because it says if an employee or agent of a licensee has violated, it seemed like if I worked for a tobacco place, I would be trying to figure out, if I was a licensee, how my employee or agent is going to have that fine.
So it says, if an employee, I'm sorry, Chairwoman Neal, it says, if an employee or agent of a licensee has violated subsection 1 for the first violation within a 24-month period at the same premises, the licensee is liable for a civil penalty.
Okay. So then my final question is, what is the rationale for how you move from 1,200 to 5,000, 2,500 to 7,500, and then the 10,000? And I'm asking that question because of the data blocks. So the data blocks don't necessarily support the fines.
Stacy Williams to Chairperson Neal. So the actual numbers from the finding structure came from collaboration with industry itself.
So the industry suggested these numbers. Interesting. Okay. So I know Senator Dignate has another set of questions. All right, thanks.
Thank you so much, Chair Neal. In trying to follow what other states have done, et cetera, a conversation that just came up was why, and maybe instead of asking why, let me reframe it. Has there ever been a conversation within your office or with public health folks to mimic this piece of legislation similar to what we have for furnishing alcohol? So if you furnish alcohol to a minor, it is a misdemeanor. And so has that ever, it's criminal, right? But it's there, and there's statutes that we have right now, and I would argue it's fairly similar to what we're discussing today. So has that conversation ever came up? And if so, could you elaborate more? I know we've talked mostly about the civil penalties and like the escalating fees and making sure that that's aligned, but has the conversation ever came up about mimicking to what we have criminally for alcohol?
Stacy Williams to Senator Dignate. Actually, I'm not going to say the conversation came up because we keep alcohol and tobacco completely separate, but if you will look back before 2019, it used to be a criminal offense to sell tobacco to a minor. And what we were finding was that, clerks, that was then putting in jeopardy their citizenship and things like that. And that changed from a criminal structure to a civil structure. And so that's fairly recent in our history that tobacco violations on the clerk went from criminal to civil.
And just to clarify, what session was that and what bill number was it?
I'm sorry, Senator Dignate, it predates me, but we can get that information for you.
Senator Spearman.
Thank you, Madam Chair. So this is all these smart people asking these really smart questions, so let me try to get it straight in my mind. So whenever there's money coming from the federal government for transportation, there's certain things that you have to do in order to get that money. And if you don't do those things, you don't get the money. And so is this kind of tied to that? There's certain monies that are available to the state. And I don't know if that's because of the tobacco settlement or what, but you mentioned in there it's like 1.8 to 7.4. So the money is tied with what we do with respect to enforcement.
Stacy Williams to Senator Spearman. Yes, ma'am. The block grant says that we have to conduct the SINAR inspections. It has to be a random inspection, and it is done, the actual businesses that are inspected, they take the geography of our state and they randomly make a self-selection of those. That is where we come with the 800 plus inspections that have to be done for SINAR in order for us to receive that SINAR block grant funding. That funding constitutes for us about $18.5 million. In order to be able to keep all of that $18.5 million, we have to maintain a retail violation rate of below 20%. If we are above 20%, then we face a 40% penalty of that $18.5 million, which constitutes about $7.4 million in loss of money to the state. And so we have to conduct the inspections, we have to complete all of the SINAR inspections, and we have to maintain that RVR of below 20%.
Thank you for that. So I have a question that's related to that. I didn't know she was going to ask that, though. But, and this is two final questions. So I was reading the SINAR guidance, and it said that yes, do the fines, prevent the selling to anyone under 21. But it also said that you should be looking at changing your sampling methodology and your protocols, inspection protocols, or revise your inspection protocols. Are you guys going to do that as well?
Chairperson Neal, so every year when we submit the SINAR report, we have to submit what our protocols are and what that looks like, and it has to be approved. So our protocols are approved, and that's even down to who are our youth inspectors. We have to have a certain mix between gender for youth inspectors, ages for youth inspectors, because of course, if we get a bunch of 16-year-old youth inspectors, people are less likely to sell to someone that presents younger, so we actually have to have a mix of inspections. All of that is done and reviewed on an annual basis. We also are not the only person in the only entity that's in that SINAR piece. There's the education piece of SINAR, and that is handled by the health industry side. And so we have lots of partnerships in that. We are just responsible for the enforcement side.
Thank you for that. And then Senator Dunyate will close us out, and then we'll go to support.
Thank you so much, Chair Neal, and apologize for my last question. I think it would be important to highlight this before we go into testimony. So when I think about like public health surveillance and going out and actually making sure that our enforcement is there for the laws that we pass, right? It's important to also ensure that we're routinely inspecting and that we're monitoring what's on the ground. Now, if there was a bill that was passed in previous sessions that said we're doing this for this reason, I mean, what have you, I think we can always reconsider that, because obviously it's not working if we're seeing the increase of uptake in youth vaping. What I would ask is, you mentioned it right now, which was the structure that we have for doing inspections within the 3-year time period. So my direct question to you is, what infrastructure do you need to get to annual inspections? How many, have you guys had a conversation as to how many folks you need to hire? Because from my perspective, if you're doing more inspections, that could lead to more fines and fees to cover more people to get hired potentially. But I think it's important to just even ask, what's the infrastructure you need to get to the annual inspections so that we can comply with what's being done federally?
So Stacey Williams to Senator Dunyate. That's a good question. The way that our structure is right now, we have 2 officers who are actually police officers, post-certified officers that conduct the inspections. They go together. They also have a youth inspector, so that's 2 with 6. If we were going to annual inspections, we would have to have 6 officers and roughly 18 youths in order to be able to get to an annual inspection structure. But keep in mind, we're not the only ones that are doing inspections. They are also we have the health partners. They go and do what's called a STARS survey, and so they're actually going through and doing inspections, and they're looking a little bit differently. They're looking, number one, at where the tobacco placing is. They are also looking at the fact whether or not they have the scanners. If they're selling to use, they just don't have the enforcement piece of it, but they do have the education piece of it. And so when they are going into a retailer and they are seeing things that are violations, they're making sure that they do the education side of it and informing them of the law, informing them of the impact. So we do have more boots on the ground than just our enforcement efforts.
Thank you for that. I honestly thought it was going to be a simple bill. And then I don't know where the questions came from, but I honestly started looking at it just differently. But I appreciate you guys answering the questions and being super thorough. So we will open up for support. So anyone that's here in support of AB 53, please come to the table, fill in the chairs. Ideally, all 3 if there's 3 people.
Chair Neal, Peter Kruger representing the Nevada Petroleum Marketers and Convenience Store Association. Of those roughly 3,200 licensed tobacco retailers, about 1,280 or so are designated as convenience stores. I'm here in support of the bill, but there was, with the questioning, the line of questioning, my support remains firm as the bill is written. But there are a couple of things, for example, I learned that there was in fact allegedly employers that are encouraging their employees, if you will, to sell tobacco to underage. This is news to me, and I very much want to get to the bottom of that because I don't believe it. What you have before you here is from the first print of the bill to the first reprint is a highly negotiated set of language between industry. I know that the health districts were involved. They're here, they can speak for themselves. But our concern was that, and support, well, let me say this, our support is that there needs to be higher employer fines, not employee fines. And I think we need to make that clear based on some of the questioning. This language addresses the employer. The question about agents is news to me too, because in the retail world, I know of no one who wanders in and starts selling in somebody's store. Either they are employees, unless we're maybe talking about 1099 or contract employees, but I even find that, at least among our members, to be not probably as factual. So the term agent, I don't know what that is. So again, we remain in support. We do believe that the electronic age verification piece that's been in place for 5 months is helping and will help. It is true that not every employer or every business has that technology, but it is free. You can pay for it, but look at a product called TrueAge. It is an open source code that is free to anybody. And the way it works is that if you take a credit card in your business, you already have the scanning technology. You have the back room that supports that credit card. It's simply when they swipe the driver's license, there is 4 pieces of information that this uses. And not all, I think there's something like 34 bits of code on a driver's license. But nevertheless, that information, that scanning technology is available free to anybody. If they haven't, a business hasn't implemented, there's no excuse for that. And that's the reason that our association supported these increased fines, to get the attention of retailers. And I would suggest that the vast majority of retailer business owners are trying to do the right thing. Do clerks make mistakes? Sure. And that's why the electronic system is helping. It's no different than a clerk when they have to make change. Remember, some of you will remember, it used to be that the old cash register didn't tell you what the amount of change was that given on a purchase of, you get a $20 bill on a $16 purchase and some odd cents. So that's the same kind of technology that's helping. We're not there yet. We have some problems with different forms. Foreign driver's license is an area we're struggling a bit as an industry with, also scanning passports. But that technology is advancing essentially every month. So the other thing that I want to say is that we want to continue work with, of course, the Attorney General, the health agencies, and in the long run, we believe that every age-restricted product, and in Nevada, that's alcohol, tobacco, and marijuana that I know of. We don't have lottery. So that should be subject to electronic age verification. The bill that was passed last session only addresses tobacco. So thank you.
Next.
Chair Neal, members of the committee, Tommy Ferraro with the Nevada Resorts Association. We'd like to thank the Attorney General's office for working so closely with us on this bill, and we fully support the office's efforts in reducing underage smoking in Nevada. Thank you.
Thank you. Is there anyone else in Carson City in support? So I'll go to Las Vegas. Is there any in Las Vegas coming up for support? Okay, seeing no one, I will go to the phone lines. BPS, is there anyone online for support of AB 53?
To testify in support of AB 53, press star 9 to take your place in the queue. Chair, there are no callers wishing to testify in support.
Okay, thank you for that. Is there anyone here in opposition of AB 53? Should come to the table. Cancers of... Go
Chair
ahead.
Neal, Vice Chair Donate, Tom McCoy. I'm representing the Nevada Tobacco Control and Smoke-Free Coalition, and we're in opposition. The Nevada Tobacco Control and Smoke-Free Coalition, formerly known as the Nevada Tobacco Prevention Coalition, is comprised of collaborating public health, healthcare, local and national nonprofits, community-based organizations, professional and medical associations, higher education, and governmental entities. NTCACSC is concerned that the current version of AB 53 fails to adequately address the troubling issue, as we've seen, of tobacco retailer sales to minors in Nevada. NTCSC strongly believes that Nevada's youth can and will continue to access tobacco products illegally until the legislature supports a more effective version of a tobacco retailer bill. There's an immediate need for increased penalties for repeat retailer violations, and those should mean increased fines for the retail licensees and not the sales clerk. There should be mechanism to suspend and/or revoke tobacco retail licenses for multiple violations. Nevada should require no less than annual compliance for tobacco retailers rather than once every 3 years. And there should be an alignment of reinspection penalties to 36 months rather than a do-over period of 24. Enforcement policy can be greatly enhanced by mandatory tobacco retail training and a continuation of youth prevention education. The current youth prevention funding ends with this biennium, and there is none proposed for the next 2 budgetary years. NTCSC is in opposition of the amended version of AB 53 and looks for an opportunity to strengthen bill language. We feel that more can and should be done to significantly decrease illegal tobacco sales to our youth and prevent addiction and health risks. Thank you.
Okay, thank you for that. All right, is there anyone else in opposition? Is there anyone down south in opposition to AB 53? We'll go to the phone lines, BPS, for opposition.
Testify in opposition of AB 53, press star 9 to take your place in the queue.
Good afternoon, Chair Neal and committee members. For the record, my name is Caitlin Gatanyan, C-A-I-T-L-I-N, last name G-A-T-C-H-A-L-I-A-N, and I'm the Government Relations Director for the American Heart Association. On behalf of the American Heart Association, I would like to express their opposition to AB 53. Although we appreciate the improvement to our current tobacco retail licensing policy, the policy overall does not reflect best practices to reduce the retail violation rate, therefore would risk the state to lose funding through SINAR. If we wanted to decrease the amount of kids getting access to tobacco products from retailers, we need annual compliance checks, license suspension, and license revocation for repeat offenders. Based on the presentation by the Attorney General's office today in comparison of other states, we should include suspension and revocation. The American Heart Association opposes AB 53. Thank you for your consideration.
Thank you. BPS, is there anyone else on the phone?
Yes, Chair. Caller, you're unmuted.
Yes, hello. Good afternoon, Chairwoman and committee members. For the record, my name is Joanna Strother, spelled JoannStrother. I am the Senior Director of Advocacy for the American Lung Association in Nevada. The American Lung Association is respectfully opposed to AB 53. Selling tobacco products to minors is a public health issue. According to the American Lung Association's State of Tobacco Control report, Nevada fails when it comes to passing policies that protect our youth. 21.4% of our youth are using tobacco products in Nevada. Kids can access tobacco products more easily in states that don't have a comprehensive license and compliance check program because retailers know there is no risk of a license suspension or revocation. Therefore, with no meaningful repercussions, Nevada tobacco retailer noncompliance rate exceeds that of 20%. The language in AB 53 does not go far enough to protect youth. A retail license that is comprehensive, which includes annual compliance checks, and a penalty structure that includes suspension and revocation of the license is needed to keep kids healthy and safe. I think that was pretty much also stated in the presentation that we just heard, and what works in other states that have lower violation rates include these components. The Lung Association would like to see the language improved and be able to reflect changes that keep retailers accountable. Thank you for your consideration.
Thank you.
Good afternoon, Chair Neal and members of the committee. For the record, Carrie Harrington, that is spelled C-A-R-I, last name Harrington, H-E-R-I-N-G-T-O-N. I am the Executive Director for Nevada Cancer Coalition. We're a partnership of public and private health researchers and advocates across the state working together to reduce the burden of cancer. Obviously, tobacco control, specifically for our youth, is a huge, huge issue for us. We respectfully oppose this bill and echo the comments of our colleagues who have also spoken in opposition thus far. Thank you.
Thank you for that. BPS, is there anyone else in opposition?
Chair, there are no more callers wishing to testify in opposition at this time.
Okay, thank you for that. So we will move to neutral for AB 53. Is there anyone in Carson City in neutral? Wow, you're neutral. Okay. I'm very interested to hear this.
Well, that can't bode well for me. Good afternoon, Madam Chair, members of the esteemed Senate Committee on Revenue. The Retail Association is neutral on Assembly Bill 53, and we'd first like to thank the Attorney General, as well as his Chief of Staff, for the amount of hard work. Mr. Kruger, I don't think, was wrong when he talked about how negotiated this particular piece of legislation was, and so we want to recognize that office for the amount of work that went into that.
Can you tell us who you are? I know who you are. Can you tell the secretary?
I apologize. Brian Wachter, Senior Vice President at the Retail Association of Nevada. We, however, have some trouble coming out of neutral on Assembly Bill 53 for a lot of reasons. The first of which is that while the rate seems high, you have to remember in Nevada, it is not a crime for anyone under the age of 21 to seek out or to purchase or to proposition a store owner to purchase these kinds of products. When you take a look at especially the other states that the Attorney General's presentation showed, most of those, if not all of those states with very low thresholds, also have a minor a prohibition against minors purchasing these types of products. In Nevada, we don't have that. And so we think that there are a number of tools that Nevada policy needs to be able to add before we decide that closing down a small business or a large business, which is going to have an economic effect on a neighborhood, it's going to have an economic effect on the current employees, especially on the other employees who weren't the clerk, perhaps, that made a mistake. We too would find it troubling that there would be a business owner whose business model would include instructing employees to make or encourage these types of purchases. I think you also heard from the Attorney General that they have the ability to rescind an inspector, especially based on a complaint. And so I think it's entirely possible that you can get beyond just those regularly inspected timeframes that they do have. And so those are compelling reasons that we feel why it's difficult for us to support this legislation, or to support. We don't want to oppose the legislation because we do think that this is something that we need to, as a state, tackle. We are prepared to do our part. You heard from the statistics that the vast majority of Nevada retailers are complying with this law. We would hate, and under the new revised version even, a retailer who's never had a violation of this matter could have an employee who makes a mistake one day and now they are suddenly faced with a fine on the first instance. And so we feel that that is something that is a lot to give up, but we do recognize that the Attorney General's office may be right that that initial fine immediately after might be enough to get us down. And then we'd also, look at that data, that last data block, especially that the chair was concentrating on. That seems to have a very large difference between the AG's inspection rate and that SINAR inspection rate. And if you look at the rest of the data blocks that were provided from the AG's office, that doesn't occur in any of those other data blocks. And so we agree that there should be a little bit more review on the data, and I hope I have made that as clear as mud for you, Madam Chair. But for those reasons, that is why the Retail Association is neutral on the bill.
Thank you for that. It's actually super clear. I was going to say something that's more like a joke. Are you going for the Bee Gees hairstyle?
If it helps you pass the bill as written, yes, ma'am.
Just asking. All right. All right. Is there anyone else in neutral? Anyone in Vegas in neutral? Is there anyone on the phone line in neutral?
Yes, one moment, Chair.
Hi, my apologies. There was a delay. I am actually in opposition to the bill. Is it okay if I still provide testimony?
Yes, Mr. Secretary. Yeah, we'll switch this to opposition. Go ahead.
Thank you. Good afternoon. My name is Megan Bolter, and I'm a public health law attorney and the Western Regional Director for the Preventing Tobacco Addiction Foundation, also known as Tobacco 21. For more than 2 decades, we have worked to raise the minimum legal sales age for all tobacco and nicotine to 21 and have developed model policies in conjunction with our national health partners to help states navigate best practices when complying and enforcing federal, state, and local tobacco retail license programs. We appreciate the opportunity to provide comments and although support revising the penalty structure for retail violations in the state of Nevada. Along with every other public health, medical, and youth advocacy group, we strongly oppose revised regulatory provisions written by the tobacco industry and some retailers, which simply create high fees for those retailers who choose to sell tobacco and nicotine products to kids in violation of federal and state law. As written, with no mandatory compliance checks nor any risk of potential suspension or revocation of a tobacco retail license, this bill does little to truly impact retail sales of tobacco products to youth in the state of Nevada. Of note, the AG's office provided evidence of the correlation of penalties to SINAR retail violation rate. To be clear, the states with the lowest violation rates correlate, not causation, correlate to penalties which have license suspension and revocation on the table. This bill does not. This state's public health partners and my colleagues have addressed Nevada's dangerously high retail violation rate of 30.4% in 2022 and 28% in 2023, putting the state at risk of losing critical substance abuse block treatment grant dollars. Even more critical is the loss in health and productivity of a generation of youth that are still being primed for a lifetime of addiction. Please note those in support of this bill versus those in opposition. Such a discrepancy in those whose sole purpose is to improve the health and welfare of youth in Nevada versus an industry, and this does not include responsible retailers, those that make a profit from the sale of addictive products that create lifelong customers, should give this state pause in passing this bill. We also support responsible business owners. A comprehensive penalty structure would ensure that bad actors are held accountable so that a retailer who continuously sells to kids upwards of 3 or more violations should no longer have the privilege of holding a license. Of particular note, the TRL annual fee in Nevada is one of the lowest, $50. Please, I beg you, inquire as to why increasing increasing the license fee by even double to $100 to help fund better inspection protocols is less attractive than raising the first penalty fine by 500%, from 500 to 2,500. And you can see the same goes for the second, third, and fourth violations. In other states, high fines are just budgeted into the cost of doing business. A license to sell an addictive and harmful product is a privilege, not an entitlement. And with that privilege comes the responsibility to act in accordance with protections, which preclude the sale of harmful addictive products to those under age of 21. Please consider, when you talk about cost, ask the schools in the state's over $1 billion healthcare cost annually due to the burden for tobacco and nicotine use, what this state is really, truly willing to pay. I appreciate your willingness to hear my comments, and I would also appreciate being at the stakeholder table when you're developing further amendments to this bill. Thank you.
Okay, thank you for that. BPS, is there anyone else on the line in neutral?
Chair, there are no more callers wishing to testify
Okay.
neutral at this time.
All right, with that, do the presenters have, no closing remarks? Okay, so we will go ahead and close the hearing for AB 53 and open up for AB 98. Assemblyman Nguyen, you still have a co-presenter down south, right?
Good afternoon, Chair Neal, Vice Chair Doñate, the distinguished member of the hardest working Senate Revenue and Economic Development Committee. My name is Yui Nguyen, and I have the honor and privilege to represent Assembly District 8 in Southwest Las Vegas. Thank you for allowing me to present Assembly Bill 98 to you today. AB 98 is set to strengthening Nevada's workforce development system so all Nevadans have the skills they need to succeed is a top priority for all of us. We often hear from employers and businesses, large and small, rural and urban, that they are facing a workforce shortage. We hear from our constituents that they want to re-enter or enter the labor force, but there are barriers of entry for them to do so. Additionally, when employers are looking at Nevada as a possible location site for their company, there are three things they ask about: water, land, and a ready and available workforce. Therefore, increasing Nevada's labor force participation rate is a bipartisan issue that, if we don't fix, will further impede Nevadan access to career pathway, businesses from prospering, and economic development efforts. This session, we've heard so many great ideas on how to strengthen Nevada's workforce development system, such as streamlining services and increasing access. One way to do this through Assembly Bill 98 that I am proudly introduced during my first session is by making sure that information flows from the local regional workforce development boards to the statewide Governor's Workforce Development Board. Currently, the regional one-stops have effective and active industry sector councils. These sectors council elevate businesses' voices from key industry areas that are aligned with Nevada economic diversification objectives. This includes healthcare, manufacturing, technology, transportation, construction, and other key areas that Nevada's resiliency relies on. However, current NRS prescribe the Governor's Office of Workforce Innovation to have their own competing statewide sector council that are redundant. A better approach is streamlining efforts so that the local sector council have a channel to flow information up to the Governor's Workforce Development Board, which the Governor's Office of Workforce Innovation serve as the liaison to. This would reduce government redundancy while strengthening Nevada's workforce development system. AB 98 is proposed cleanup language for NRS pertaining to the Governor's Workforce Development Board and industry sector councils, which are managed under the Governor's Office of Workforce Innovation. The objective is to streamline workforce development efforts so that there is more alignment and regional focus. AB 98 is suggested language to revise NRS 232.935. This serves to clean up and update this section in NRS because the board is no longer titled the Governor's Workforce Investment Board. Rather, it is now referred to as the Governor's Workforce Development Board. Additionally, this section revises direction for the Governor's Workforce Development Board to have industry sector councils. Currently, there are competing and duplicative industry sector council because there are both regional sector council partnership and Governor's Office of Workforce Innovation statewide sector council. For example, in Southern Nevada at Workforce Connection, there are 7 efficient and effective industry sector council established per the region's comprehensive economic development strategies. The sector partnership elevate relevant and timely discussion on in-demand industries and occupation as it pertains to strengthening Nevada's workforce development system. In Northern Nevada, at Nevada Works, with the Good Jobs Challenge grant that was awarded to them, there are currently plans to establish regional industry sector council/partnerships. Nevada Works and Workforce Connections are working together to bring this regional industry sector council model that has proven effective to both regions of the state. These regional sector partnerships allow for a bottom-up approach for information sharing regarding workforce development issues and opportunities to flow up government channels. Therefore, the Governor's Office of Workforce Innovation no longer should have or be required to have competing statewide industry sector council. Instead, these sector councils should be replaced by the regional sector council. This will increase collaboration and cooperation between the state and regional workforce development organization, and it will strengthen alignment between workforce development agency, and it will reduce duplication. And with your permission, Madam Chair, I would like to introduce and welcome back to the building former Assemblywoman Irene Bustamante Adams, who in her current role as the Chief Strategy Officer for Workforce Connection, to complete the rest of my presentation.
Okay, thank you for that. Good to see you, Bustamante Adams. Go ahead.
Hi, thank you, Madam Chair and members of the committee. For the record, my name is Irene Bustamante Adams, and I do have the privilege of serving as the Deputy Director and Chief Strategy Officer for Workforce Connections. We serve the counties of Clark, Lincoln, Nye, and Esmeralda, and our counterpart, Nevada Works, serves the other 13 counties. Our Executive Director, Jaime Cruz, presented last time as a subject matter expert on behalf of Assemblyman Wynn's invitation. However, he had a work meeting that could not be moved. I'll provide a brief background and then highlight successful milestones thus far regarding the industry sector councils. So last year, we aligned our regional economic development. We aligned with LVGA, which is our Regional Economic Development Authority, our Chambers of Commerce, our school district, and our higher ed partners to convene these industry sector partners. We followed the comprehensive economic development strategy that is identified in these sectors and through the SEDS that we did here in this region. It was a heavy lift to launch all 7 industry sectors, which is healthcare, general and advanced manufacturing, information and communication technologies, transportation and logistics, clean technologies, business and financial services, and creative industries here in the Southern Nevada region. The model is being validated, like Assemblyman Wynn said, by the U.S. Economic Development Authority, because they just granted, not too long ago, our Northern Nevada counterparts approximately $4 million to set up this model in the north. The model is based off of a nationally recognized model called the Next Generation Partnership model, and these are the factors that are included in it. It has to be employer-led. It cannot be the other way around. It has to be the employers leading from the front. And when we do convene, the employers, we are there to listen and to identify short, mid, and long-term goals that they have for their talent needs. It includes small and medium and large businesses, and we have a common thread which provides more opportunity for collective impact when we're designing talent pipeline. We, the local workforce board, K through 12, higher ed, so forth, we are called acquisition partners in the model. And our role, like I said, is to listen. Plus, we customize training for the industries collectively. And so that way we have better impact. And so for a long time, it was the other way around, and we told employers, here's a training model you need for your talent pipeline, pick which one you want off the shelf. That was very frustrating and not productive, and so this next gen model turns that around. Some of the highlights of success that we have had so far, one of the needs that the employers have said, and I'm talking about the manufacturing sector, they said they wanted to concentrate on K through 12 as one of their talent pipeline strategies. So in high school, we heard from them that they wanted critical thinking, problem-solving skills, teamwork from their young adults. So one solution was to have a reverse job fair for these employers through a student showcase that we did in March, a couple of months ago. The pilot convened the students that acquired manufacturing, automation, and robotic skills during their high school years. And it was wildly successful. We had 20 employers. More than 35 students participated. They came prepared with their resumes. They were able to meet with several of the employers. There was job offers, there was internships, and the goal is, right, to keep our talent here locally. We plan to replicate that model in other high schools. In middle school, the strategy that the employers wanted was to connect to middle school students and let them know the in-demand occupations for their industry in manufacturing. And so we partnered with the Nevada Department of Education they selected a virtual platform to use to get teachers access to industry professionals and have kids learn about the different industries. It's not the only strategy in middle school, but just one of them. And so through this virtual platform, you could learn about the day in the life of a certain career in manufacturing. You could participate by giving a virtual tour of your workplace. You could discuss career pathways, and this is all interactive for the students, the teacher, and the employers. And then in elementary, to close out, the employers highlighted in-demand occupations through a coloring book. And so it's a very interactive coloring books that teaches about the in-demand occupations. It already starts to plant the seed in the elementary school of what the future jobs will be when they get ready to graduate. And so we have done a pilot in a few schools, and it has been received very, very well. And it starts to let students know what would they like to be when they grow up. And so these are just examples of how this regional sector partnerships have evolved and are working a lot better than the statewide ones that we created when we formed GoEd in 2010. I think the intent during the Great Recession was a great idea, but we realized that there's a different need within the regions, and the more localized and regionalized we can make it, the better. And that ends my testimony, Madam Chair. Thank you for the opportunity.
Go ahead.
Thank you, Ms. Irene Bustamante Adams, on that presentation. I also want to make sure that we brought in all of our phone a friend in case the Senate has questions. We have a representative from the Governor's Workforce Investment Board on standby should the committee member have any question. And just wanted to reiterate that you never thought you would hear coloring books in Senate revenue, but here you are. We're talking about coloring books. And we'll be ready for questions. Thank you very much.
Thank you for that. Members, any questions? Senator Spearman.
Thank you, Madam Chair. Thank you so much. Maybe I missed it, but some of the sectors, does that include energy and how that looks like it's how energy is now starting to shape the economic development, not just of the country, but specifically here in Nevada?
Yui Wen, for the record, Assembly District 8. I will defer to my phone a friend in the south.
Yes, thank you. For the record, Irene Bustamante Adams, Senator Spearman, 100%. The SEDS classified it as the report, the SEDS report classified that under clean technology. So it's a lot broader than clean energy. And so, yes, 100% that is included.
Thank you. And so that my follow-up question is that as more and more of the energy sector develops and it bifurcates, if you will, not just in electrification, but I think RTC down south got $3.8 million to look at how they employ hydrogen fuel cells and the buses, and then the $8 billion that has been allocated from the Biden administration that people, I think about 2 or 3 organizations here in Nevada have applied for. And so I guess my question really is, are we looking at not just what is now, but what's next, and how we might be able to leverage the dollars that are here right now for the future, especially when we start talking about advanced manufacturing and how that relates to the development of our diversified economy here. Is that clear?
Yes, I think I understand the question. For the record, Irene Bustamante Adams. So Senator Spearman, yes, and because it's employer-led, they know their industry and where it's headed. And so I would say that you are spot on. It is not just existing talent pipeline needs, but what's coming in the future. And for example, in the clean technologies arena, we were part of that application for the hydrogen grant from a regional standpoint, because one of the members of the Clean Technologies is Air Liquide, and they brought to our attention the opportunity to partnership with UNLV, ourselves, and submit the application with support. So yes, it's futuristic, and it is for all the sectors, not just for clean technology, but also manufacturing and healthcare and so forth.
Thank you for that. So I potentially have 2 questions, but the first question is coming from Section 3. So you guys add the members of the local workforce development and other business representative from industry sectors, and then you have this sub 2 collaborating with the local workforce development boards. So is there now increased participation, or are you using this language to make the collaboration stronger? Because I just remember there being a bottleneck, right? The locals are doing one thing, but not necessarily increased coordination between all groups to align.
Assemblyman Wen, can I respond?
Yes, please go ahead. Thank you.
Oh, thank you. I can only see one person on the screen, so I just don't want to be out of turn. So for the record, Irene Bustamante Adams, Madam Chair, yes, increased participation, coordination, because that was part of the barrier that was existing. And so not only having the employers lead the conversations, then we circle around them so that we understand their needs, but coordination between the Governor's Workforce Board, so that we are in alignment and on the same page of what we need from a regional standpoint. So yes, that is the intention, and is to increase participation and coordination.
Thank you for that. So the second question from Section 3, I understand adding the business representatives to drive the narrative, at least in terms of what the need is. What are you ramping up for, right? But even with this collaborative piece, how will this help the colleges, the community college that has a workforce program, ramp up into this, right? So we know, right, that even if you have multiple pieces of collaboration, there's a need for flexible dollars. What we saw in the interim over the past couple of years, I don't know if it's 2 years or 2.5, with the Sandy grant, right? there was an ability to take the Sandy dollars, which were more flexible than the WIOA dollars, in order to ramp up new programs. And then the colleges had more ability to, I guess, engage and create more flexible training programs so students or community could participate. We know that the Sandy dollars are expiring, if not expired. So how does this help a college such as Community College, who is running a workforce program, ramp up? Because they have barriers with the federal money, just the same way as everyone else has barriers with the WIOA money. And what we also know to be true is that if you're not extremely poor, sometimes the federal money misses the buck in terms of helping to train people who meet different categories of need.
Thank you. For the record, Irene Bustamante Adams. Madam Chair, the collaboration is because the community college and the other higher serving institutions are at the table. And so we are listening to the employer at the same time to understand their needs. So they have let us know, here's what I need, and then which skill acquisition partner, like the community college, can develop the training that the employer needs. And they are asking for shorter term certifications. So here's how we're braiding. And so with the grant dollars, for example, the Sandy grant, if we have a training that the community college has developed for the employer, but the cost is, $10,000 for the individual, typically, WIOA dollars would be able to pay up to $8,000. And then the constituent, the individual, would have to be out of pocket for the remaining amount. But because of this coordination, what we're able to do is cover that remaining cost so the individual does not have to come out of pocket. So one, the community college is being mindful of the training that's needed. It's not a cookie cutter approach. It's customized for the industry. Number two, we're collaborating regionally to make sure that we are covering the training for the constituents so that they don't have to come out of pocket. And then thirdly, because of the collaboration, we may be able to give that individual a stipend while they're taking the training. All that before, the coordination, I can say, was not happening. And because we're in regular communication, because of this regional approach, that's why we have a stronger strategy to address the talent pipeline needs.
Thank you for that. And then my final question is related back. I'm still going to get on the colleges, because one thing I get where you're going, but how will this particular bill help remedy? There are barriers in the dual enrollment challenges for workforce. So when I hear, so community college can go after and certain populations that may be in CCSD's population, but CCSD doesn't want to share that student because they're getting points for their numbers. And so community college can't pluck from aged out or 18-year-olds or 17-year-olds that they may want to get into the pipeline. And so how do we deal with that barrier? Because I've been hearing that a lot, that it's like, well, we don't want to let our student enroll in your program because we need our numbers on this side of the equation. So there's no cross-populating, right? So when we say we want to customize and ramp up at the college level, then the K-12 won't allow their students to be in the program because they're running their own workforce program. I think there's over-duplication, right? That's not allowing the students to actually take advantage of who really can customize and ramp them up, because we know that one of the weaknesses on the K-12 side is they can't do that. They don't even have the capacity to do that, yet they're tying the hands of other groups because they don't want to share students, and that's a problem. So you can collaborate, and this is great, But that's a key barrier when each one is counting numbers to turn back to the feds.
Thank you. For the record, Irene Bustamante Adams. Madam Chair, you're spot on. And because of the collaboration between our Economic Development Authority, ourselves, and the other people that you mentioned, I know that the LVGA is the one that's taking the lead on this, and they are developing the Talent Pipeline Council. And what that means is that it's going to be the K through 12 leader plus the other presidents of the Community College of Nevada State College or University, I'm not sure if their name has changed officially, UNLV, and making sure that dual credit is one of the top priorities, right? Because we have not solved the problem yet. They are going to be starting these conversations and strategy sessions this summer, and the LVGA has raised their hand to take that lead. And so, is everything fixed yet? No. But I know that that's the alignment and strategy that we're moving forward towards.
Well, thank you for that. I just hope that one of the strategies is that someone's going to have to stand down to allow the customization for the actual constituency to get them in the pipeline. And although K-12 is at the table, K-12 may not be the party that should be holding the line on cross-population to allow someone to take advantage of a program because they don't want to reduce their numbers. So I think there needs to be a real conversation about saying, if you are getting some kind of federal allocation in the K-12 system, you might need to reduce your interaction here to allow the colleges to actually do this work with the workforce boards, and you educate kids and help them read. Okay, that's probably too much. I'm sorry. Okay, let me turn this over to Senator Spearman.
Thank you, Madam Chair, but I don't think you're sorry. But anyway, Ms. Bustamante Adams, I just have a question because the chair dealt with K-12, and what I'd like to deal with is the evolving workforce needs as it relates to jobs that are currently here and the ones that we know are going away within the next decade, and some of them will be gone by 2030. And so my question is, has there been any thought given, maybe I missed it, any thought given to working with specifically labor? There are some jobs within labor organizations that will not be here in the 2030s. So the people who are currently in their late 30s, maybe mid-40s, are we doing anything to help them identify what some of their skill sets are right now and how they might leverage what they know how to do now with their next? You understand what I'm saying? How do we take the people who are working on typewriters right now and teach them, how to program computers?
Thank you. For the record, Irene Bustamante Adams, and labor definitely is in the conversations. We are waiting for session to end so that we could take a deeper dive, but we know that transition needs to happen. We've had conversations, but like I said, building a strategy will have to wait for the next 28 days until the session is over so that we could concentrate on putting details to that. But yes, it is relevant and on the radar, as well as those that are going to be aging out of those, labor pools. Yes, it is part of the comprehensive strategy that we're addressing. I just don't have as many details as I do for the others.
Thank you. So quick follow-up, if I can make a recommendation to make sure that the community colleges are really an active partner in this, because it's the community colleges where many of the people whose current work is going to go away, this is where they live. In my district specifically, there are a number of people in Senate District 1 who are part of the service and servicing industry, and as those become more and more automated, those jobs will be going away. You're talking about retail clerks in grocery stores, people in warehouses, that sort of thing, even people in the hospitality industry. And so I don't know that we have a lot of time to wait to make sure that those people know that the community colleges have a place for you. And maybe it could even be something where we could leverage federal dollars from DOL to help that training get started while they are still in an active work environment.
Thank you. For the record, Irene Bustamante Adams, Senator Spearman, I can assure you with 100% confidence that they are at the table with us. Sometimes the conversations are daily on how to leverage the available dollars to tackle the fact that AI will automate a lot of the jobs, and that how is community college to be the solution. For example, we partner together to regionally to apply for grants to build the training centers. So the first one, which is out in Henderson, which targets the manufacturing sector, we supported the community college in order for Southern Nevada to get the funding. So that's the collaboration I'm talking about. We are looking at who would be the best lead, who takes the leadership role in the grant, so we can build that regional collaboration. And so that is just one of 3 training centers that will be opening up in the Southern Nevada region. The community college is the lead in each one, and so we are intimately involved in that strategy together. And there's no infighting of who's going to get the dollars, because we know that it benefits the region as a whole. So they are participating, not just as a participant, but as a leader in the conversation. So yes, we are working together more than what I've ever seen.
Okay, thank you for that. So we will open up for support on AB 98. Is there anyone here in support? Fill in all 3 chairs. Is there anyone down south in Vegas?
Madam Chair, there is somebody in neutral, and I'm not, and there's somebody watching to just to observe your awesome committee.
Thanks. Go ahead.
Good afternoon, Chair and members of the committee. Dylan Keith, DYLA and KEITH with the Vegas Chamber. We would like to thank Assemblyman Nguyen for bringing this important bill forward. We do support this legislation. We're happy for the collaboration. Thank you so much.
Thanks.
Good afternoon, Chair Neal, members of the committee. Anthony Ruiz with Nevada State College. Happy to support Assembly Bill 98. I think the sections in particular that are really helpful is the push to regionalize some of these boards. I think, we have participated on these industry sectors, now partnerships under this bill. Our approach to economic development is regional in nature. The comprehensive economic development strategy was mentioned, and I think as we could continue to make that process more efficient, it allows us to come together with the request sort of more streamlined and in better order. So I think that's really helpful. Nevada State College hopes to be part of that in the future. We already are and hope to continue to be part of that. And I think we have this coordination really push down the regional level to help us apply for things through the SEDS for grants, things like through the Economic Development Administration. So I just think the bill makes a lot of sense, really appreciative of the sponsor for bringing it forward.
Thank you for that. Next.
Good afternoon, Madam Chair and members of the committee. Ashley Cruz with Career Nevada for the record, here on behalf of the Las Vegas Global Economic Alliance. LVGEA appreciates Assemblyman Nguyen for bringing this bill forward. When working together with business and industry, we strongly urge and encourage thoughtful measures like Assemblyman Nguyen's bill that reduce governmental hurdles and create efficiency so the needs of our communities are better addressed, including workforce challenges as they directly impact our economy and overall quality of life. And just to add, as Irene Bustamante Adams mentioned, LVGEA is a part of taking the reins on the task force and establishing that network of counsel, and we'll continue those conversations during the interim.
Thank you for that. Next.
Good afternoon, Chair Neal, members of the committee. For the record, Jack Giese, representing the RTC of Southern Nevada. Last name is Giesea. We're a member of the Transportation and Logistics Industry Sector Partnership through Workforce Connections. We'd be thrilled to see those perspectives included as part of the larger GoEd board, and we think that's a very integral part of a strong workforce development pipeline. Thank you for your support.
Thank you for that. Is there anyone else? Okay, seeing no one, we'll go to the phone lines for support of AB 98.
Chair, the public line is open and working, but there are no callers wishing to testify in support at this time.
Okay, thank you for that. Is there anyone in opposition to AB 98 in Carson? Is there anyone in opposition in Vegas to AB 98? Okay, seeing none. Anyone in neutral to AB 98? Oh, sorry. Anyone in opposition on the phone?
Chair, there are no callers at this time.
Okay, so we will move to neutral. State your name for the record.
Thank you. Katie Gilbertson, the policy analyst for the Governor's Office of Workforce Innovation and liaison to the Governor's Workforce Development Board. Thank you, Chair Neal and members of the committee for hearing this bill. Goen will be testifying in neutral for AB 98. We see this bill as having a very positive impact on strengthening and aligning Nevada's workforce development system. AB 98 is proposed cleanup language for the NRS pertaining to the Governor's Workforce Development Board and industry sector partnerships, which are both managed under the Governor's Office of Workforce Innovation. The objective is to streamline workforce development efforts so that there is more alignment and regional localized focus, which allows for a structure that ensures that information flows from the local regional workforce development boards to the statewide Governor's Workforce Development Board. Workforce Connections in Nevada Works have elevated business voices through these industry sector partnerships in key areas that are aligned with Nevada's economic diversification efforts. This includes healthcare, manufacturing, technology, transportation, construction, and other key areas that Nevada's resiliency relies on. Hearing from these business leaders helps us understand workforce issues that they are experiencing. This will reduce government redundancy, which will strengthen Nevada's workforce development system. Thank you.
Thank you for that. So BPS, is there anyone on the phone line in neutral?
Chair, there are no callers at this time.
Okay, thank you for that. So we'll call Assemblyman Nguyen. We have one final question from Senator Spearman.
Thank you, Madam Chair. Maybe it's a suggestion, maybe not a question, but as you move through the training and the reskilling of the workforce and all of the other branches thereof, is it possible to include in there child care? Those types of services will be important for those who are developing a new skill set or even trying to increase or better the ones that they already have. And so working with making sure that there are folks on board that are looking at that as well would probably be a real good idea.
Thank you, Senator Spearman, for that suggestion. It's truly duly noted in here, along with my very scrupulous notes that I took this whole time. Again, many thanks again to Senator Neal, Chair Neal, Vice Chair Dunyate, and the rest of the very patient Committee on Senate Revenue, because we're on the third hour. So Yui Wen, again, Assembly District 8 for the record. You have heard from Business Association and Regional One Stop that are the experts on the ground in our local neighborhoods and communities who are the closest and best aligned to understand the workforce need the businesses in their regions have. Streamlining industry sector council so that information can move up the chain to state legislator, reducing redundancy, increase career pathway for Nevadans, and strengthen Nevada's workforce and economic development goals are truly, truly why I'm here in front of you for AB 98. So I would ask for your support of AB 98 and look forward to working with all the members of the Senate to get this passed through. Thank you so much.
Thank you for your testimony. So we will go ahead and close AB 98, and we will open up for public comment. Is there anyone in Carson City for public comment? Is there anyone in Las Vegas for public comment? Is there anyone on the phone lines for public comment?
Chair, the public line is open and working, but there are no callers wishing to provide public comment at this time.
Okay, thank you for that. So we will go ahead and adjourn Senate Committee on Revenue.